Welcome to the Docketing Excellence Webinar Series.
Welcome to the Docketing Excellence Webinar Series, which is sponsored by Black Hills IP and the SLW Institute. Black Hills IP is an accurate, efficient, and cost-effective U.S.-based IP docketing and paralegal service provider. The SLW Institute is an educational group created by the Schwegman, Lundberg, and Wissner firm, which aims to provide insightful and useful information to the IP community. For this webinar series, we have pooled together docketing experts and managers from the Schwegman firm, Black Hills IP, and their respective clients and customers to help educate on key docketing challenges and issues, and to share best practices on how to overcome them. The Docketing Excellence webinar series is free. There are 3 more webinars after this one in April and May. To listen to our past webinars or to register for future webinars, go to the Docketing Excellence series tab of the Black Hills IP website, which is www.blackhillsip.com. Also, just a note, we launched a new version of our website last week. So those of you that have gone to the webinars tab in the past, that's changed. And now we have a Docketing Excellence series tab for all information on webinars, seminars, and our Docketing Excellence LinkedIn group. Those can all be accessed through the Docketing Excellence tab. In the future, we'll be adding additional content through that tab on our website as well. We'd love to have you check out our new site. The webinar that we're presenting today is the 14th in this series. Today's topic is the EP validation process. We've allowed time for questions at the end of the webinar. Questions may be submitted using the Q&A button on the control bar on your screen. You can submit a question at any time during the presentation. The question will be held in a queue until the end of the presentation. The presenters today are myself, Bryn Williams, and Karen McCartney. I'm Ann McCracken, the president of Black Hills IP. I'm a patent attorney with 20 years experience in patent prosecution. I was a partner at the Schwegman firm for 10 years, and I was also a full-time law professor and directed the patent prosecution program at Franklin Pierce Law Center for 5 years, which is now the University of New Hampshire School of Law. Bryn, can you introduce yourself?
Hello, I'm Bryn Williams, a European patent attorney with Creation IP based in Glasgow in the UK. I've been a patent attorney for 13 years with extensive experience before the European Patent Office. With me is Karen McCartney, the senior paralegal for Creation IP, also based in our Glasgow office. Karen has been in the profession for 28 years, the majority of that time being spent on European patent validations.
Hi, everyone.
Thank you, Bryn and Karen, for being a part of the program today. Bryn, I'm going to turn it over to you to get us started.
Okay, today, as Anne says, we're going to talk about the European patent validation process. This can be considered a 3-stage process, which is driven by the receipt of 2 documents from the European Patent Office. Stage 1 is the acceptance of the text, which is driven by the receipt of the intention to grant a European patent, the equivalent of a US Notice of Allowance. Stage 2 is the grant stage, which is the period between the issuance of the decision to grant document and the date of grant. Stage 3 is the validation stage, which is the period following the date of grant. We will discuss each of these stages and the documents involved in turn. The first stage, stage 1, is triggered by the receipt of the intention to grant document. On the slide is an example of this document, as issued by the European Patent Office. This is the equivalent to a Notice of Allowance issued by the USPTO, and the intention to grant communication is issued under Rule 71.3 of the European Patent Convention, and is also known as a Druck Exemplar or Form 2004C.
The intention to grant document is an invitation to complete these tasks. The primary tasks are to approve the text and verify the bibliographic data. We will discuss both of these in more detail in the next slide. With regard to translations, to issue a grant certificate, the European Patent Office require all patents to show the claims in each of the official languages, that is, English, French, and German. So, for an English language case, translations of the claims into both French and German are required. In addition, a grant and publishing fee, similar to a US issue fee, is due. Further fees for excess claims and page printing may be required, and these fees will be shown on the intention to grant.
Let's consider in more detail the requirements for approving the text and verifying the bibliographic data. Care must be taken to ensure that the text is in line with the client's expectations and includes previously filed amendments. This is vital because this is the text that will go to grant and will be the basis for the granted patent. Checking thoroughly is also important because it has been known for pages to go missing from the file and the final document. Ensure all the text and drawings are present. Additionally, the examiner may have made amendments to the text to, for example, comply with the formal requirements of the European Patent Convention or to correct typographical errors he has noticed. If such amendments have been made, their location is cited on the communication. These amendments need to be checked to ensure they are acceptable to the client. If not, they need to be rebutted in the response. It is important to check the current bibliographic data is correct, as shown on Form 2056, attached to the intention to grant. Responding to the intention to grant is, in effect, the final opportunity to correct any defects centrally at the European Patent Office prior to grant. If this opportunity is not taken, the defects will have to be corrected before each individual office where the case is validated.
Moving on to the docketing requirements. For the acceptance of text, the EPO sets a 4-month term for responding to the intention to grant. The EPO 10-day mailing rule applies, so the due date is calculated by adding 10 days to the date of mailing and then a further 4 months to that date. We are often asked, what is the purpose of the 10-day rule? It is intended to compensate for postal delays. The European Patent Office assume that 10 days is a worst-case scenario and even the slowest mail service will manage to deliver within 10 days. There is no option to extend the 4-month response term. However, if the deadline is missed, the EPO will inform you of the missed action and allow the case to go into further processing. Further processing provides an opportunity to restore the case with no loss of rights, as long as all the tasks in the intention to grant are completed. These tasks must be completed within the period allowed for further processing, that is 2 months. A further processing fee of €255 must also be paid.
Assuming an acceptable response to the intention to grant has been filed, the examiner will issue the decision to grant under Article 97(1) EPC, triggering the second stage of the validation process. The decision to grant is issued on Form 2006 and states that the patent will be granted based on the documents attached to the intention to grant. Referring back to our earlier comment, this is why we have to be certain that the text of the intention to grant is accurate and reflects the client's wishes. Further down the page, the document states the date of mention of grant in the European Patent Bulletin. This is shown in the lower of the 2 boxes on the screen. The date itself is underlined in red on the slide. This date is the grant date and is written in the European style of day followed by month and then year. The date of grant is important for 2 reasons. The first reason is the grant date sets the deadline for filing divisional applications. Divisional applications have to be filed whilst the parent application is still pending. Therefore, the deadline for filing a divisional application is the day prior to the grant date. On the grant date, the application has become a patent, and therefore it is too late to file a divisional. Second reason the grant date is important is that it sets the deadline for completing the validation process. Validation is separating the granted European patent into national patents in a similar way to the nationalisation of a PCT application into national patent applications. The validation stage is stage 3 of our process. All validations must be complete no more than 3 months from the grant date. This deadline is not extendable. It is a drop-dead deadline. If missed, validation can only be revived by successfully restoring under national laws in each country. Succeeding in a restoration action is an extremely difficult and expensive process.
Another key consideration in stage 2 is the docketing requirements with regards to renewals, particularly in relation to the renewal date, when the renewal date will fall due. For a European patent, the renewal date falls on the anniversary of the filing date. If this anniversary is before the grant date, the renewal fee is due to the European Patent Office. If the anniversary of the filing date is after the grant date, a renewal fee is due to each national office where validation is to take place. Good docketing practice should record that, depending on when the renewal falls due, the renewal payment is either a single fee to the European Patent Office or multiple fees to the national offices. Take, for example, a case where the Year 5 renewal date falls due before grant. The renewal fee is therefore due to the European Patent Office and is $1,127 US. However, if the renewal date had fallen after the grant date and the validation had taken place in France, Germany, the UK, the Netherlands, Italy, Spain, and Ireland, the renewal fees alone for this patent would amount to $1,895 US. For the year of grant only, it may be possible to save the client money by pushing the grant date out beyond the 5th year renewal date. So how do we push the grant date out? The only way to influence the grant date is during stage 1 of the process. Before you file a response to the intention to grant, once the response to the intention to grant is filed, the European Patent Office will process the response and issue the decision to grant, setting the grant date. In our experience, the period between filing the response to the intention to grant and the actual date of grant varies, but is never less than 6 weeks. Therefore, if you delay filing your response to the intention to grant until less than 6 weeks before the renewal date, you will, in our experience, push the grant date beyond the renewal date. If the renewal date is between 6 weeks and 12 weeks after the deadline for responding to the intention to grant, you could purposely not file a response to the intention to grant. This would trigger further processing with the associated opportunity to push the grant date out further.
Moving on to stage 3, validation. The validation process must be complete within 3 months of the grant date. This is not extendable. Validation requirements vary from country to country. The validation requirements are completed by either a local national associate or a European patent attorney firm who can work across all European Patent Convention jurisdictions. National requirements vary from country to country and may include the payment of official fees to the National Patent Office, the filing of signed power of attorney forms by the patent holder, the lodging of translations of the approved text, or appointing a local national address for service. As a client to a European patent attorney firm, your assistance will be required in obtaining signed power of attorney forms. All other requirements will be met by your European Council. Power forms will also be provided by your European Council. For certain countries, the appointment of an address for service is not compulsory. However, we would always recommend appointing an address for service. This will ensure all national documentation issued from the National Patent Office is sent to a specific point of contact. Should no address for service be appointed, there is a risk that any notifications issued are either sent to the original European Council who is representative for the European application, or, as we have seen in the past, sent to the patent holder. By appointing an address for service, you can be assured that any notifications are sent to a specific point of contact.
Considering renewals again. When a renewal fee falls due within the validation term, an automatic extension is applied by each of the national patent offices in which a national renewal fee is due. This is normally extended until the validation deadline. The rule of thumb being, a renewal cannot be paid when the validation has either not yet been finalised, can still be done.
Before we go on to national requirements, a quick word about the London Agreement. I'll give you a moment to read this slide. It has long been the desire of the European Union to have a single European patent, which covers the entire Union without the need for national validations. The stumbling block has always been translations. The cost of translating into all the national states' languages is prohibitive when compared to the current system, which allows you to pick and choose countries you wish to validate in, depending on your budget. The London Agreement was brought in to try and move the member states of the EPC towards some form of harmonisation in an effort to reduce the translation burden on applicants. At this point, we will briefly mention the unitary patent. In December this year, it is expected that the unitary patent will be introduced in Europe, which will allow a single designation to cover multiple countries. The existence of a unitary patent means, for example, that only one renewal fee will be due for that collection of countries, and only one litigation will be required to prosecute for infringement in those countries. Presently, if, for example, you wish to validate your European patent in 5 territories, say the United Kingdom, France, Germany, Spain, and Norway, you would designate each of these individual countries for validation. From December, as the UK, France, and Germany have agreed to be bound by the unitary patent, there will only be the requirement to designate 3 territories, the unitary patent territory, Spain, and Norway. The exact workings of the unitary patent are not yet settled, but the majority of issues should be put to bed in the coming months, and we intend to prepare a further webinar for Black Hills IP and the SLP Institute for broadcast before the summer. To assist in understanding the national validation requirements, we have prepared a validation matrix of the current requirements. I emphasize current requirements. When we do the unitary patent webinar, we will update this matrix to reflect the new system. For each country, the matrix lists whether a power of attorney form is required to appoint a local agent as an address for service and the translation requirements for that country. There are 3 levels of translation requirements. Countries for which no translation is required, that is, they accept the European patent in the form it was granted. By that we mean the description in one of the official languages of the European Patent Office and the claims translated into all 3 languages of the European Patent Office. There are 8 countries in this bracket, and these countries are full signatories to the London Agreement. There are also claims translation countries, which accept the description in one of the official languages of the European Patent Office, but additionally require the claims to be translated into their national language. Finally, there are full translation countries, which require the entire granted patent to be translated into their national language.
With regard to docketing, your European attorney will handle the validation process on your behalf. However, there are some points to note to ensure you do not run out of time. For example, the original power of attorney form is often required, and whilst this can be filed after the validation deadline, in Greece, at least an electronic copy must be on file by the validation deadline. Referring back to our validation matrix, just to emphasise the point, of the 39 EPC member states, 25 of them require power of attorney forms. Greece is highlighted in red because of the requirement for an electronic copy of the power of attorney form to be on file by the deadline.
Another requirement to consider with regard to running out of time is that of obtaining translations. Translations which are ordered close to the deadline often incur urgency fees, and we strongly advise issuing early instructions, particularly for the full translation countries. This slide highlights those full translation countries on the validation matrix. Staying on the subject of translations, there are some cost savings to be made by using translations prepared for one country in another. For example, both Italy and San Marino require full translations, but share the common language of Italian. Therefore, only one Italian translation has to be prepared for both countries. Similarly, Greece and Cyprus both accept Greek translations, so a single Greek translation can be prepared for these two countries. This also applies in Serbia and Montenegro. Serbia requires a full translation, and the Serbian claims can be filed in Montenegro, a claims translation country.
Finally, we are often asked about the cost of validating. Whilst it is impossible to give exact figures, which are useful in every case, this slide shows a rough and ready guide to the relative cost of validations in the 39 European Patent Convention member states. The green countries are by far the cheapest, and these are, not surprisingly, the countries which have no translation requirements. The red countries are the most expensive countries and are generally full translation countries, Norway being the exception. The orange countries are the mid-cost countries. I emphasise the text at the bottom of the slide. These are indicative costs and greatly depend on the length of the description compared to the claims. A very long claim set will skew the table. And thank you for inviting us to deliver this webinar, and we hope everyone found it of benefit. I also hope you could all understand our accents and we didn't speak too fast.
Thank you very much, Karen and Bryn. I seem to be having a little bit of a technical problem on my end, but we got through all the substantive slides before we lost the connection. I hope the audience didn't lose the connection, and that was just me. So I'm going back in now so that we can go into the Q&A portion of the program. Let me get logged back in. Anyway, I want to remind the audience that today's program can have questions submitted through the Q&A button on the control bar on your screen. If you have questions regarding Black Hills IP services and processes, please contact Jim Brophy, our Vice President of Sales. And we will, let me just get into this Q&A box here. Okay, we have one question. And I'm going to give Karen and Bryn, oh shoot, you guys can't read it because I lost my, all right, let me read it to you. It was my understanding that under Article 141.2 CBE, if annuity and renewals were due within 2 months of grant, they are payable 2 months from the grant date. If I understood your explanation properly, if the annuity renewal comes due before the validation deadline, but after the grant date, it's extendable to 3-month validation deadline. You want to read that? The top question here is the one we're looking at.
Yes.
Oh, sorry.
In response to that question,
There you go.
In response to that question, most countries have the set term of a 2-month term payable from the grant date. However, the assumption must be that if you have not validated in that country, a renewal is not due. So where the rule says it is 2 months, most countries will have a further month or a further term up until the validation deadline, in which someone may validate that patent and at that time pay the renewal fee. And this extension is normally a grace extension. I hope that answers your question.
Okay, good. Let's go on to the next one. What happens to a design patent granted in the EU? Does it have to be validated? What are the renewal fees?
Okay, the European Patent Convention covers more than the European Union. Designs are European Union right, and they are a unitary right across the whole of the European Union. So there's no validation to be done because there's no translation requirements. The whole of the European Union could agree on a system for designs. So no, there's no validation. It's a single unitary right.
Yeah, and the renewal fees are due every 5 years on EU design registrations.
Up to 20 years? 5 years.
Interesting. So designs are a little simpler.
Yes.
Designs are a lot simpler.
When it comes to that aspect, at least. Maybe not on everything else, but okay. How do designated countries know the EP allowed case is being filed there, and how is a payment made? Oh, here it is. So you're working with local agents in the countries for that?
Normally, your European associate can work locally in front of some of the EPC states, or this would be instructed via a national associate, and they would know the fees that are required to be paid. For example, at the French Patent Office, there are no fees to be paid at the UK Patent Office, and the rules vary differently across all of the European states, and these fees would be driven by the offices, and it would be paid by the associates, and they would vary.
So if I was working with your firm to go through the process at the EPO, and then I got to the validation stage, as the client, am I responsible for contacting the agents in the countries where I'm going to validate, or will you do that for me?
That would be normally your European Council would do that.
Okay.
And then where we can work, for example, we are based in the UK, and we can register for French, register at the French Patent Office. However, we cannot register at the Spanish Patent Office. We would normally instruct a Spanish associate who's aware of the local fees that are required and the translation requirements.
Okay. All right, next question. How and when are annuities paid, and then also back annuities? So is there a different process for the back annuities and the regular annuities going forward?
Normally going forward, when we know the grant date, and for the example where the renewal is due within the validation period, the foreign associate or your European Council would pick that up, and these would be encompassed in the validation formalities. So they would be paid in line with the validation.
Okay.
Most EPC states have a grace period of 4 months. So if you miss a deadline to pay the renewal, they are not drop-dead deadlines. They normally have a grace period, and you will be issued with a deficiencies notice regarding that renewal. But most foreign associates in the EPC would pick up that a renewal fee is due, and this would be encompassed in the validation process.
Okay.
You can tell who's the expert in European patents here.
These are great answers, Karen. When you file in the EP, can you only designate countries at this time? So we're talking about the different countries for the validation process, and I think this question is going to, at what point do you determine? Do you have to designate them all up front? Can you decide later? How does that work?
It basically depends on the type of European application you're filing. If you're filing a European, which is derived from a PCT application, the designations must be selected on filing. We now have in Europe, we now have one designation fee, which covers all states that are available on the time of filing. For a European Paris Convention application, the process for designating the countries is not on filing, it would be 6 months from publication of the European application, but similarly to an ex-PCT application, you would only pay one fee and all countries at that time would be available. There is no longer a process of picking, for example, 3 validations in comparison to the 39. There is one fee that covers all countries.
Okay.
Is it true to say that a divisional application can only designate some countries as the parent?
Yes, it's the designations are based on the filing date that are available at the time of filing. So if you're filing a European divisional, it's only regards to the designations that were available on the parent application date. If your divisional had an application date of 10 years ago, for example, then maybe Montenegro was not available at that time, so your new divisional wouldn't have that option.
And national phase applications coming out of a PCT, the filing date is the date of the
PCT.
PCT.
And you use the phrase ex-PCT.
Deriving from a PCT.
Deriving, so based on a national phase,
national
a
phase,
PCT national phase. Okay. Okay, let's keep going. We got more questions. Is there anywhere to see in one place all the designated countries where validations have taken place?
When you log on to the EPO register, there is an option to view the legal effect for each national patent. My experience has been that it's not always correct, but it should give you a guidance to see where a patent has been validated and where it has not been validated. This is solely dependent on the national office keeping the EPO register up to date. So I would only ever use that for guidance purposes. You could request a status request from a national associate and they can quite easily check their registers.
Similarly, there's on a SPACEnet, ESPACENET, if you look up a European patent, there's the family tab, which will list the family members, but again, it's not terribly accurate, probably gets information from the same source.
Okay. Okay, next question is about assignments. If a European patent is assigned to a company after the grant of the European patent, registration of the assignment in each validated country is needed. What are the consequences of not registering in the validated countries the assignment? In which countries would there be severe consequences? And I'm sure that's individual country law. I don't know if you have any experience or comments on that or not.
I mean, I would say the consequences would be that your patent is in the wrong proprietor's details. And then if you're open to infringement, your patent is not based with the correct proprietor details. An assignment is recorded after grant and within the 9-month opposition period, you can lodge the assignment at the European Patent Office and the European Patent Office will show the register has been updated. However, after the grant date, liability must be that the assignment is recorded in respect of all of the validated states in which you're going ahead. I would always recommend any assignments are recorded prior to the grant date. It may be that the effective notice is 1 week before the grant date. That is totally acceptable. All national offices will accept that the EPO has recorded the transfer prior to the grant date and will affect that in the national office.
Okay.
But if the assignment is recorded 1 day after the grant date, the liability would be that the assignments must be recorded nationally.
And even if that assignment itself occurred after the grant date and you couldn't have recorded it prior to the grant date, it's still the same, right?
Yes,
you still
yes.
have the responsibility to record it in the national offices.
There are some countries who will accept that it has been recorded at the EPO within the 9-month opposition term. However, some countries require that the European patent form is translated into national languages, and there are different filing requirements that makes it more complicated.
So if you have a particular country that's of interest or concern, always recommended to contact an agent in that country, right?
Correct, correct.
Okay. Could you review the manner in which one can ensure a renewal fee becomes due at the EPO rather than the validated stage, stage 2 rather than stage 3? So I think this is what you were talking about in your slides, right?
Okay. I'll talk about this because I'm less of an expert than Karen, so hopefully she'll be able to confirm whether I've understood it or not. So this is trying to push the grant date out beyond the renewal date. The only way you can do that is to try and delay the date of grant. The first easiest option is to reply to the intention to grant as late as possible. As we said, we believe we've never seen it shorter than 6 weeks from sending the date of grant or the intention to grant off to the patent being granted. If it's longer than 6 weeks away, the renewal date, what you can do is not file a response, and then the European Patent Office will write to you and say you haven't filed a response. If you file a response within the next 2 months, pay the further processing fee, then we'll restore the case, and they would then send it to grant. And if you did all that at the end of that 2-month window, you would have get another 10 to 12 weeks. So if it's possible, just delay filing your response to the intention of grant until the last minute. If that's not going to be enough, then you can ignore the due date for filing the response and I'll go into further processing and get another couple of months that way.
Okay. Karen, you confirm?
Yes. Bryn picked that up, okay.
Okay. Please confirm that for design patents, annuities are due every 5 years, and only from the EU.
No, design patents that Hague.
No, I think it's a European design, registered design. They refer to them as design patents.
Yes, yes. So that understanding is correct. For an EU design, annuities are due every 5 years, and it's only one renewal fee, which is due at the EU IPO. You do not pay renewals in all of the designated states. So that is correct.
I can't remember. Is it date of filing or date of registration? Date of filing.
5 years from date of filing?
Yes.
Okay. So let me read the question. You're like anticipating. Validation countries are sometimes given new patent numbers. Do we need to mark our database with the new number, or can we continue with the EP number? That's a great question, because some countries will assign a new number when it's validated, right?
Yes. There are several countries that do assign a new national number. Normally, we would say that the EP patent number is sufficient. However, for Italy, the Italian Patent Office can only renew on the basis of the Italian patent number. And most renewal service providers will ask, do you know the Italian patent number? So yeah, I would always say you should capture this information somewhere. For example, in Germany, they will issue late renewal notices, and it will refer primarily to the German national number. Within the form, it's deep within the form, you will see the European patent number. So if you record that on your system, you then can easily locate that.
Okay, so it would be a best practice to track the number assigned by the individual country when the individual country assigns a new patent number, right? If the choice is made to push the grant date out to allow for an annuity savings, are there extra fees if the further processing option is chosen?
The additional fee for further processing is €255. This is a flat fee. Further processing across the EPC is normally 50% of the omitted fee that you have not paid. However, for the 71(3) stage only, there is a flat fee of €255, and so that is the fee you would have to pay.
So you have to kind of balance how much are you going to save versus what's the cost of going into further processing, right? If the EP granted patent was validated in 5 countries, for instance, and then a divisional was filed, can you validate in more than those 5 countries for the divisional application?
Yes, you can. However, you can only designate the states in your divisional application that were available on the parent application. So, for example, if your parent application at the time of filing designated 14 states and only validated in 5, your new divisional has the option of the 14 states. And then at the validation stage, you can then go forward in those 14 states. You're not restricted by what you've validated in your parent.
So let's say, and I'm just making this up, Norway was not available through the EPO when I first filed. Then later when I filed the divisional, if Norway became a part of the EPO, I can't still go and get to Norway through that patent. I would have had to have filed direct in Norway, right?
Yes.
And Norway is a bad example because they are available, but that's the idea.
Yes. The idea is you can extend your rights to the additional countries which are now available, but you can still have the original set of designated countries.
Okay. Other than Germany, are there other validated countries that issue a new patent number?
This is putting me on the spot.
Well, and I'll jump in here. I think about a month ago, we had a webinar. Christy Wheeler, who you guys know, was one of our presenters, and she had a slide in our program that listed there's about half a dozen of them that have the assign a new number. So I know we have those in one of our previous webinar slides, and I'll refer the viewers to that, the listeners to that.
I would say that Italy, Spain, Austria, Germany, these countries all appoint a new number.
Okay, but that might not be a
comprehensive list. No, I would check your slide.
Okay. Validated in, is that Italy? Validating in Italy. It seems to take quite a long time to get the Italian patent number, which is needed by our annuity provider, as you explained. Italy is quite behind on posting this information on their website. Any workarounds or ways that you guys have dealt with that problem?
Yeah, we have had the exact same problem. The only thing I would say is when a case is validated, there should be a filing receipt that is provided by your European Council, and this should cite the number. So in theory, you should get that number with the validation report. And if you don't get that, I would ask for that. The other option would be contacting an Italian associate to check their database. I know I've gone onto their database and it's not particularly helpful. So that would be the only workaround.
But that filing receipt, that's
the filing receipt.
Check.
The filing receipt would have that on it. Yeah.
When validating in Germany, France, and Great Britain, are back year's annuities due? When are they paid?
There are no.
The European, most countries use renewal fees to subsidise the patent process. The EPO doesn't receive renewal fees after grant, so it has to levy them beforehand. So there would be no back annuities because the renewal fees would have been due to the EPO prior to grant.
Okay. From a docketing standpoint, is it best practice advice to create your validation records in your database upon receiving the grant date? So when do you set up in your docketing database the validation countries?
In our own database, that is exactly how we would set it up. Once you know the grant date, then you can copy across. Most IP software will copy across from your parent. There's also an opportunity if you copy prior to that and you don't know the validation deadline, and then you manually adjust it in each entry. Whereas I would always suggest update your European, and then whatever software you're using, it would copy from your parent, and then you're getting the correct date.
So it pulls in the information from the parent
From the
record
market,
into the record for the validation matters. Okay. Does utilizing further processing at any stage affect the term of the patent?
No, the European patent, once it's validated in the national phase, in the national stages, is 20 years from date of filing.
Okay, good. Okay, back to the question about assigning new numbers in some countries. Is the new number the patent number? Your speaker called it a national number, but I'm not sure what that refers to. So it is a patent number,
Yes,
right?
it is a patent number. That's, apologies for any confusion. Yes, the national number is the patent number in that country.
So the way to think of it is there's a patent number for the application that granted from the EPO, and some countries just use that number from the EPO as the patent number in their country too.
Correct.
But in a handful of countries, they assign their own patent number.
Yes.
Is that the right way to think of it?
Yes, and I would say they assign their own number in addition to the EPO patent number.
Mm-hmm.
Most countries, if you refer to the EP number, so they will have two numbers.
Okay.
The EP patent number within that country and their own national patent number. But if you refer to either or, it's the same. It's the same patent.
Okay. Okay, we got so many questions rolling in here. I'm just trying to get them straight. Okay, so we just did this one about the new numbers. Okay, for translations, powers of attorney, and other validation requirements, would you say it is better to docket in the EP matter alone, or each country you're validating in individually?
My recommendation would always be to docket it individually. That way you can ensure any national formalities are docketed nationally. For example, your entry for Greece, you know that you require a power form and you'll be looking for that. So depending on the selection of countries, if you had 10 validated countries to monitor, 5 may require power forms, the other 5 may not. So I would always suggest docketing individually.
Okay, good advice. All right, Mary's helping us out here, and she says national numbers are issued at least by Germany, Italy, San Marino, Turkey, and Greece. Now, she's got the disclaimer like us at least. There may be a few more, and I know, like I said, Christy Wheeler had these in the slides a few weeks ago, but at least Germany, Italy, San Marino, Turkey, and Greece issue their own number in addition to the EPO's number.
Thanks, Mary.
Yes, thanks, Mary.
I was on the spot there.
Oh, here's another person helping us out, and this one also adds, what's on this list? Peter adds Germany, Spain, Austria, Italy, Turkey, and Denmark. So I don't think we had Austria and Denmark on the previous list. So, you know, there are probably 6 or 8 countries out there that do it, and we just want you to be aware. And I think Karen's tip about the fact that annuity providers require the country's patent number in some instances is a good thing to be aware of from the docketing standpoint. Okay, patent number, when we use the term patent number as in registration number, are those the same terms? So we're using those terms interchangeably. Okay, this one's specific to Spain. Request for examination is needed in countries like Spain from April 1st, 2017. What is the deadline for it? Do you know? I know you don't necessarily practice directly in Spain.
I don't know, but if this is a Spanish validation of a European patent, the European patent would have been granted, so there'd be no request for examination. So I assume it's a straight Spanish
National?
Straight Spanish national. Don't know.
So contact a Spanish agent
Yeah.
on that, definitely.
Yeah, the UK law is harmonised with the European law, that it's 6 months from date of publication of the application. So it's quite likely to be a similar time, possibly similar to that, but pass.
Okay, here's another question. I think this is again directed to terminology. Some of the agents for the validated countries send us a filing receipt. You mentioned that earlier. Would you say that the filing receipt number is the same as that country's patent number?
Yes, I would say so. However, in my experience, most filing receipts come in the national language and can more often than not be very hard to decipher. Sometimes the number on the filing receipt could be a payment number. So if you're unsure, I would always check with a local associate as to what the filing receipt number is.
Great. Okay, I think the remaining questions that we have, there's a couple questions. Let's see, we got that one about the filing receipt. A couple questions about our slides, and will our slides be available? Yes, they will. They'll be posted on the Black Hills IP website. If you go to the Docketing Excellence tab on the Black Hills IP website, you'll be able to see past webinars, and these slides will be posted in a few days on the past webinar slides of our website. The audio recording will be there as well. So I'd like to again thank Karen and Bryn for their time. They're very, very knowledgeable on this subject matter, and you guys did a great job, so we really appreciate that. And I'm going to hold you to that promise to do another webinar that we don't have scheduled yet on the unitary patent requirements as they become more formalized and the procedures come out. We will bring you guys back to do that. Then I just want to remind everybody that the next webinar in our series is on April 19th. So normally we go every other week, but just note this one's next week, April 19th at 1 p.m. Central. The topic is handling opposition proceeding docketing in Europe. So to go to this to register for this webinar, go to the Black Hills IP website. And thank you for participating today. We hope you will join us for this and other webinars in the Docketing Excellence webinar series. Thank you, everyone.